Welcome. This is Professor Blakey, and the title of today's video is What is a Copyright? So let's get started. What is a copyright? Are you seeking knowledge? Well, then you've come to the right place. Glen Maven Digital Publishing. What is a copyright? A copyright is one of several different types of intellectual property, along with patents and trademarks and other types of intellectual property. These are exclusive rights in immaterial things. For example, a copyright is not a right to a physical thing, but it's the right to exclude others from copying an original work of authorship. A copyright is defined as an original work of authorship fixed in a tangible medium of expression. A copyright is an original work of authorship fixed in a tangible medium of expression. An original work of authorship fixed in a tangible medium of expression. So it has to be original, and it has to be a work of authorship, and it has to be fixed, meaning made physical. Copyrights are part of a larger group of rights called intellectual property. Intellectual properties are exclusive rights in immaterial things. In this case, the copyright is the right to copy. So say you own a physical book. That's your book, but you don't have the right to copy it. You have the right to own the book, you could sell the book, but you can't copy the book. The author is the owner of a copyright from the moment of creation. Say they wrote a book, the person wrote a book, and then never filed for copyright registration. They're still the copyright owner. They're the owner from the moment they wrote the original work. Copyright being an original work of authorship, the originality being the origin with the author of an original work. And then it has to be placed in some tangible medium, whether it's text, audio, digital, some sort of medium of expression so that we can see what it is that you're claiming it's an original. Then if someone else copies that person's book, at that point, the author can register their copyrighted work, and then they can bring a lawsuit. Their registration has to be brought and filed and registered with the U.S. Copyright Office before you can file a lawsuit. It doesn't have to be registered before the person copied, the potential defendant copied it, but it does have to be registered before the lawsuit. The author has the rights initially and originally to the author, and then under US law, if the author wants to sue someone for copying their work, they have to register with the United States Copyright Office. So what does it mean to be an original work of authorship? You might think of the word original as perhaps creative, but it doesn't mean creative. It means origin with the author. If the work was origin with the author, then it's original. That's sometimes called a modicum of originality. It's sometimes called a minimum originality or a threshold of originality. It just means that it was origin with the author. Then it is copyrightable. Another way of looking at that or thinking about that is that facts are not copyrightable. Facts are not origin with the author. Facts are things that exist in the world. So the case that's cited for that is called Feist Publications, where one telephone company asked permission from another telephone company if they could copy the listings, the names, phone numbers from one book to another. And the original book, Rural Telephone Company, said, no, you can't copy. These are our listings. We work to put them together. But were they really original? No, because they put together facts. You can't get a copyright on facts. Sometimes you could get a bunch of different facts and compile them together and maybe get a copyright on the way you organize them, but not in the underlying facts. And to organize names and addresses in alphabetical order is obviously not an original organization, nor are the facts copyrightable. There's three different ways to transfer a copyright: assignment, license, work for hire. An assignment is the sale of all rights, including the title and any right to use or copy the work, to distribute it, perform it, everything. It's like signing the pink slip to your car. It's not yours anymore. A license means a permission, and that is just a permission for some part of the work. Perhaps you wrote a book like Harry Potter, and then you licensed the exclusive rights to make films to Warner Brothers. So J.K. Rowling still has title to the work, and the right to make films is held by someone else, Warner Brothers. So that's splitting up what's known as the bundle of sticks. The bundle of sticks is title, possession, and use to a property. And those can be split where one is the title holder and someone else has the right to make the movie. Work for hire is when there's no written transfer. It's just that you are an employee of a company and you're hired to work as a writer or photographer, and any original works that you make, the company is considered the author from the moment of creation. So if you work for the LA Times, you don't have to sign a license or assignment every day for your work. It's just automatically the LA Times is considered the author under the work for hire doctrine. The right is an intellectual property right because it's the right to copy. It's not the right in the physical thing. So if you own a book, that's your book, but you may not own the copyright in the book. This concludes today's video. What is a copyright?